Welcome to the 7th session of the ACMHangouts hosted by Arts Council Malta. During these sessions, we have met with creative professionals, experts, and professionals in general to discuss a number of different topics which are of interest to the creative sectors. All these sessions are being streamed on the Arts Council Malta Facebook page and are then available on the same page in case you would like to check them out at a later date. Today, the topic is relatively technical, but pretty important for the creative sectors, and this for a number of different reasons. Today, we are going to be focusing on intellectual property rights, tackling questions such as how can one define intellectual property and how can artists protect their rights? What are the necessary steps to take when creating new work? And how can protecting these rights ensure sustainability of the same work? Our panel today is made up of lawyer Dr. Luke Dalli and Mr. Steve Vassallo from the Malta licensing representative from the PRS for music. Throughout this session, we will have a number of different speakers also joining us through Zoom. Today, instead of starting off through the usual introduction, I will be asking some questions, in order to get the context and to get an idea of what intellectual property is. So, Dr. Dalli, to kick off the session, I feel that it is important, it is relevant to start by defining intellectual property rights. So, can you please provide us with a brief overview of what the term is and what it implies, and also the laws which regulate it?
First of all, I thank you for this invite. It's a very interesting. I've seen the other sessions. They have been very interesting for us professionals, but also for the actual artists and all those involved in the artistic and creative sector. Unfortunately, 1 hour is not enough to even brush the topic of intellectual property. It's so vast. You have years of courses at university when it comes to the legal part of intellectual property. But today I will very concisely give an overview of what an artist needs to know about his intellectual property, his rights, his artistic rights. In a nutshell, intellectual property refers to the creation of the human intellect in their various forms and mediums at the end of the day. Such intellectual goods can be both tangible and intangible in their nature. Intellectual property is treated as an asset capable of being owned, sold, and licensed. But only, this is very important, I highlight this and I will say this throughout this session, only when expressed and recorded. For example, an idea alone cannot be afforded intellectual property protection. The law regulating intellectual property around the world, not just here in Malta, revolves around the maxim of protecting products of the human intellect, in the same way as we protect, for example, physical property and other assets. Thankfully, in Malta, the legal instruments in place protect both forms. In the legislative form, but also affords judicial remedies in court, where if one of your rights is breached or is being attacked, you can resort to the remedies in the judicial sector. We are also parties to international agreements which are reflected in the Maltese law. One of the most important ones is the Berne Convention on artistic work. The laws of Malta regulating intellectual property are various, and I'm going to list the most important ones here. We have Chapter 597, which is the Trademarks Act, which within it we have the areas, for example, of unauthorized use, falsification, and penalties allotted to such breaches. You have Chapter 417, which is the Patents and Designs Act, where the article is dealing specifically with infringement in this area of unknown ownership, for example, forfeiture, compensation, limitation, damages, and employer-to-employee relationships. We have obviously the most important act, which is the Copyright Act, where I think even Steve here can expand further, because there is also collecting societies as part of the definitions within the Act. But also, the intellectual property is dealt to in the criminal code. There are criminal breaches to, for example, trademarks, to, for example, any other, to patents that might resort to criminal action and be heard by a criminal court.
So this, just to give an example, would be in case someone copies the work, for example, copies your work.
Let me give you an example which I had very recently. Someone was importing products with a trademark on them. The person cut out the trademark and resold the product. That is a criminal activity that obviously revolves around the intellectual property. That is, in this case, the trademark.
Okay.
That is one of various examples we might resort to the criminal code. And finally, Chapter 488, which is the Enforcement of Intellectual Property Rights Act. So, as you can see, it falls under, intellectual property falls under three main realms, which is the civil code, the criminal code, and obviously the competition law within the Maltese legal framework.
Okay, and you referred to trademark, but we will be going into that later on. But what about copyright? Can you maybe define copyright just for the sake of whoever is following and maybe is not 100% sure what it is and how you protect it?
Copyright is a very, very vast term. It's not. You can't pinpoint 2 points in a certain subject and say, look, copyright and, for example, trademarks. It's very vast, but I'm going to give, again, another concise explanation and legal description.
Yep.
It's a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright, for example, we might have books, music, scores, paintings, sculptures, film, computer games, databases, advertisements, maps, technical drawing, audiovisual work. So it's so far-reaching, the description of what what constitutes a copyright. So that I'm partially giving an example. Copyright gives the creator of an original piece of work exclusive rights to it for a limited time period. I think that's a very concise and interesting description. Ideas and information themselves are not protected, as I said before, and the protection is afforded to the manner in which they are expressed. Generally, in Malta and even in most of the European countries, the duration of copyright is of 70 years post the death of the creator.
Okay.
So as soon as the creator of the copyright dies, he is afforded 70 years of rights over that particular copyright object or script or whatever. Then that dies out and it can be used by anyone without having a licensing agreement with the creator.
So, for example, I can use a classical piece of music, but I cannot use music composed by a composer who died, for example, 50 years ago.
50 years ago, exactly. Our legal framework grants a 70-year period post death of the creator. Some countries, although it's not the usual setting, require copyright formalities and registration for its establishment. In Malta, we follow the teachings again of the Berne Convention, which is 1886. So copyright and such rights are not something of like very some modern right. In 1886, there was the Berne Convention for the protection of literary and artistic works, where copyright is afforded automatically and does not need to be registered with any government entity or high authority regulating intellectual property in the land. And Malta follows that as well. Hence, registration in our country is voluntary and not mandatory, following again the Berne Convention. Once an idea has been reduced to a tangible form, like, for example, securing a fixed medium, a drawing, sheet of music, photo, videotapes, it needs to be a fixed medium. The copyright holder is entitled to enforce the exclusive rights attached to it. The concept, some historical background of copyright dates back to 1662, where the English Licensing and Press Act created the so-called idea of giving an artistic expression rights, and rights which are enforceable. That is the most important, because if you have a right which is not enforceable, it is no right at all. For a piece of work to be afforded copyright protection, it needs to satisfy certain requisites, such as the nexus, and this is very important, the nexus between the person claiming copyright and the work being claimed. I can't claim copyright.
I think I need a bit of an explanation.
I thought it was simple, but I tried to simplify it. But so the nexus is the connection, the link. You need to establish the link between the person claiming intellectual property, copyright in this case, and actually the piece of work. So if you have that, that is a very important requisite to be afforded copyright rights on your work. Also, we in the legal sphere, we also talk about originality and fixations, which are the golden rules when it comes to affording copyright protection. I don't know if you want me to go into licensing as well, because it's quite a vast subject. I'll try.
Yes, maybe just we can present it through a possible scenario. So let's say, for example, I wrote a script, for example, and I wrote it. So that would be my work, right? Because I wrote it.
Yes. It might be. Okay, you might have written the script yourself. You might have been in a pool of writers, so you have the joint ownership as well. But let's consider the sole owner of the work. Yes.
Exactly. Let's consider this. So if for example, I pass this on to you for you to use it for a number of years, so that would be kind of me providing you with the license.
I think this is a very important point that you're raising, and throughout these past 8 years where I have been the legal counsel to the Arts Council, I have always spoken to the artists in one very clear manner. You need to write it down. In Latin, we say scripta verba vola, scripta manent. That means whatever you say, vola is up in air. Whatever you write can be seen. So it fixes, it solidifies whatever you're saying. So. Yes. If you are the owner, the intellectual property owner, and you will need to pass on a licensing right to someone else, you need to have a licensing agreement. In which licensing agreement you need to lay down all the clauses that relate to the relationship between the person giving out the rights and the person receiving.
Okay.
In no case, if not expressly written down, these rights are passed on as not as ownership. You do not pass directly the ownership by a licensing agreement. You need to write it down that, listen, in this agreement, I am also passing on the ownership of the intellectual property piece or piece of music or whatever. So it needs to be expressly written. If not, you are just being afforded the use. The use of whatever intellectual property medium or piece of work that you're regulating in that agreement.
So the property always lies with the person who created that
ownership
particular work.
Always, undoubtedly, with no reserves, lies in the person that creates the piece of work.
Even if you are commissioned.
So, commissioning. If someone commissions a particular artist to create a piece of work, there is no gray area in this. And I've seen so many people confuse this situation. The intellectual property lies with the person creating. Okay. There is no sum of money that can buy my intellectual property unless it is expressly given by the author, by the script writer, by anyone else. So when someone commissions a script writer, for example, for a panto, I'm going to give a very particular example. The producer is giving money, is forking out money for the production to happen, not for the rights pertaining to that script. If the producer wants those rights, the author has to expressly write down, give permission, written permission to the producer to transfer the ownership of the intellectual property. Bar that, if that doesn't happen, then the intellectual property will always lie with the creator of. I have seen so many producers say, listen, I have paid for this work, this is mine. That is not yours. Forget it. The law does not afford any transfer which is not given by a written agreement.
And this is very important, especially in the context where, for example, the work then is stored, for example, in the future, or is streamed. That's something which we need to discuss at a later stage during this conversation. So I think, as you're saying, it's very, very important that all this is written down, stipulated
without
in
regulation,
a contract, right? We're referring to writing it down in contracts.
This is a cry more than anything to our artists. The only asset you possess is your brain, is your talent, is your voice, is your pen. Keep it strongly to your chest. Do not dish out ownership of your work. Keep the ownership yourself. Give licensing rights, give rights for people to use even in different territories. But always keep the ownership close to yourself, because that is the only thing that will give you the powers over that work. I have seen artists produce excellent work and then just dish out the ownership of that work to someone who maybe has a bit more cash than the actual author, and he buys him out.
Yes.
You know, keep it close to your chest. Give licensing agreements, give the rights of use, whatever. But keep the ownership of that piece of work very close to yourself.
Yes.
Because you regret it. And I've seen artists who have regret giving...
and you lose work, you lose potential income, you lose a number of things. And you mentioned another scenario which is also interesting and very, it's happening all the time. When you co-create a theatre performance, a piece of work, how do you go about that in order to avoid misunderstandings in the future? So how would you tackle that?
So, it does come out of our joint authorship regulations and rules, but most of the time it is best always to regulate that co-author, joint relationship by an actual physical agreement. It's ex lege, okay? What happens? You always have Article 11 of the Copyright Act that regulates, but it is a very broad part of our law. So every specific piece of work has its own story. So I would advise, obviously, advise is a big word. Take my words as a very generic legal perspective, and every piece of work needs to be advised by a particular lawyer that you believe can help you throughout the process, and because obviously every case has its own merits. Generally, the piece of advice that I would give is sit down and write an agreement between the authors about where this work will go, potentially, if it will be toured, whatever. Write it down, and you'll have a fixed document that regulates the relationship between the different co-authors.
So you would need to ignore for a minute that you are best of friends and that you have maybe worked with the person for a long time.
Unfortunately, friendships are many a times are temporary.
Exactly. I mean, in this case, it's something which happens,
I'm being very blunt here. I'm
yes,
sorry. I know people love their friends, love their relationships, and whatnot. But unfortunately,
it happens.
You have brothers, you have fathers, and their children that fall out. how easy is it to just disagree on an argument, on something, on a particular topic, and just fall out?
Exactly.
Like that, you will be regulated even if such things happen. So I gave you a very short overview of what the law prescribes, what the law entails. But at the end of the day, all my advice has always been, if you want a regulated relationship, lay it down. Lay it down, write it down. An agreement doesn't need to be complicated, doesn't need a lawyer for it. You write down whatever you're agreeing upon, 2 signatures, and you're done. That's sealed. That's a sealed deal.
Yes. And with that, I would like to conclude this first part of definitions, let's put it that way, with a short clip which was sent to us by Mr. Matthew Pisani, who is the Director of Industrial Property Registrations at the Commerce Department. And he sent us this short clip about trademark.
Hi everyone, and thank you for giving me the opportunity to share with you some information on the importance of trademark registrations. I wanted to start by explaining what a trademark is and what it does. A trademark is basically a sign that is able to distinguish the goods or services of a business from those of other businesses. Trademarks can be represented graphically and consist of words or figurative elements, or a combination of both. Perhaps you never thought about it, but every day we come across hundreds of trademarks. A strong and reputable trademark is crucial to business success. That is why trademark protection is so important. It is also important to have an innovative trademark in order to attract attention and thus attract more customers to your product and service. But sometimes it may not be enough. And so your trademark needs to be easily recognized and recognizable by other brands. I will never stop saying it, you need to register your trademark. Registration gives you a unique advantage of not only having a distinctive and robust trademark, but also helps you enjoy exclusive rights to both the name and the logo. A strong trademark can open up a wide range of opportunities for your business to grow and gain recognition even abroad. As I said, a unique and distinctive logo distinguishes your business from that of your competitors. Like any precious asset, a trademark must be protected. Your business could be badly damaged if someone started using your brand to advertise the product or service, even more so if that product is not of good quality. What does the trademark registration process involve? Its validity and the related fees. The process is very simple and straightforward. Applications for registration of a trademark can be submitted online at www.ips.gov.mt, and each application must contain the name and/or representation of the mark, the name and address of the applicant, the name and address of the representative or attorney, provided that the applicant wishes to have one, a list of the goods or services in which you are seeking to register the trademark in, and a fee of €115. After receiving the complete application, the office carries out the internal examination procedure, and if everything is in line, i.e. there is no previous registered trademarks that is similar or identical, we'll proceed with the registration of the mark. The term of protection of a registered trademark is 10 years and can be renewed every 10 years, as long as the owner wishes to do so. The trademark renewal fee is €90. For more information on how to protect and register your trademark in Malta, visit the website of the Commerce Department on www.commerce.gov.mt or call us on 2569 0340. Thank you for your time and attention. Have a good day.
Thank you, Mr. Matthew Pisani. And now I would like to introduce Steve in this conversation. So Steve, your work focuses on music, and I would like to know why is it important, is it relevant for musicians to bands to protect their rights, and how do you help out as PRS?
So first of all, thank you for inviting me on behalf of PRS, and as also Dr. Luke explained very well, PRS for Music is one of the 176 collection societies from all around the world. Basically, our operations are based off collection and also licensing the music user. It's important that when someone is using music in a public place, which falls under the Copyright Act, Chapter 415, clearly says that when you use music in a public place outside the domestic environment, you need the permission of the creator. That's the Copyright Act, Chapter 415. Now, a creator, a music writer, automatically, when they record a piece of original music, important, this sound has to be original, they are the copyright owners. Then they decide if they want to do the work of chasing around where the music is played, performed, asking for the money, invoicing and all this stuff. Or else they can join a society like PRS, and the creator is giving permission, giving the rights to the collection societies to collect royalties on their behalf and distribute the royalties back. This makes PRS as a non-profit society, because we distribute the money that we collect, we keep a small percentage to run the operations. This is very important because a society like PRS exists because of our members, of the members. PRS, just PRS, we have around 148,000 members from songwriters, publishers, music creators, basically. And these members come from all around the world, including Malta. We have territories in Malta, Great Britain. We have Cyprus and also Gibraltar. And then we work hand in hand together with the other societies. For example, an example like our neighbors, Italy, they have their society is called CI. Germany, they have GEMA, and we work together. This means that if a member of PRS, let's say a Maltese member of PRS, the music, their work is publicly performed abroad in another territory, they still, we can still collect the rights on their behalf, because we contact the society of that territory, and the territory then pays us and we pay the member. Okay. So this is very important to understand. When you are a creator, you have to choose. You have to say, I want to be the owner of my property, my intellectual property, or else I can join a society like PRS, so they can work on behalf of my rights. And I think this is very important nowadays as well. Thanks to the internet, we can see that very vast of the music is now international. Also, many Maltese artists are focusing internationally. So, a society like PRS, it's very helpful that one can join with them.
Exactly, it would be very difficult for an artist to track
of course,
her work or his work if it spreads around the world, I would
exactly,
guess.
and also we have a disagreement with the other societies, and we have a very good relationship with all societies, and there's also the mother society of all societies, and we work under regulations by the board. So we have Pressapoco the same regulations. So as you said, yes, I think it's very important for a songwriter, for a creator, to join a society like PRS, for example. Yeah.
And Steve, what are the most common challenges which you face? I mean, this is very important for musicians to kind of to approach PRS and to say, I have this body of work, so can you help me protect it? But is it done enough? Is it done well? Is there anything which needs to be done in order to make it better?
Well, I think first of all, in the entertainment music industry, there's never enough. One can always learn, and maybe the problems that we face is the lack of education regarding what is mine and what is yours. Okay. Nowadays, the access for music is much more freely, meaning that nowadays you can play music via a laptop, via a mobile phone, for example. So everyone thinks that the music, in this case we're talking about music, is free, it's free of charge. It is not free of charge. As I said, when you use the music in a public place outside the domestic environment, you need the permission of the copyright owner. So that is very important, and that is the first obstacle that we find in explaining the music user that, listen, someone created that music, and you're going to use that piece of work to enhance your business or to put up a show, for example. So you need the permission from the creator. Now, instead of you going to deal directly with the creator, there's a PRS. We are also regulated by the Copyright Board of Malta, and there are certain regulations that we need also to obey. One of them are the tariffs, for example. We have tariffs for the music users, which are different tariffs. And they are a fair tariff. Why I'm saying this? Because if you have, for example, a small shop, let's say a 50 square meters shop, and you would like to obviously put music for your clients, for example, you're not going to pay a huge license which will cost you a lot of money, like, I don't know, a club, for example, which the main purpose is the music. So there are tariffs which are regulated by the Copyright Board of Malta, which makes sense for the music user. And once you obtain a license from PRS, you are granted to use the music under those tariffs, obviously. So there are tariffs for example, for background music, there are tariffs for live music, and so on.
Background music, I think this is important and very relevant.
It's very interesting, and I'd like to move forward with what Steve is saying. Before we said the only asset that an artist possesses is his, in this case, his music. The collecting society is doing the work you would not be doing yourself, which is time-consuming, which is almost impossible, Steve. So many artists come up to me and tell me, listen, why should I be a member of a collecting society? And I just revert the question back. Why shouldn't you be a member of a collecting society?
Yes.
Your main income, maybe not your main, it's not always a full-time job, but it's income. It's income that you can receive out of people playing your talent, playing your music.
Exactly.
Why not be part of this family? It's a family at the end of the day.
This is how the work becomes then sustainable as well. Because
100%.
it's
100%.
Exactly. And to add with this also, we use the technology of today to track music.
yes.
So, for example, broadcasters, okay? Imagine I created a song, it's out there, and I have to listen all the radio stations and TV stations to monitor where my music is. It's impossible.
It's impossible. Exactly.
PRS, we have a system which monitors, tracks the broadcast, and this system gives us data with the time, date.
Very Shazam-oriented.
Yes. How much was played.
Listening.
Exactly. And thanks to this data, we can distribute fairly the money back. In the old days,
Exactly.
the radio disc jockeys or presenters, they used to make this playlist manually. It was a bit of a headache, but I don't want to go in that area. So now we have the technology. The technology is there, and a society like PRS invests in this technology. Okay, it's good to point out as well that when you join a society like us, for example PRS, the writer is going to pay a fee and a lifetime fee. So for just one lifetime fee, you have all this vast technology, information, someone who's collecting your royalties, distributing back, and so on. So
One lifetime fee. Imagine, I'm going to give an example of someone who is a very good friend of mine, that's why I'm mentioning him. Imagine Freddie Portelli today, 80-year-old, and I think he's close to 80 today. All these years, people playing his music anywhere possible, if it's a supermarket, if it's, I don't know, a hairdresser, if it's a restaurant. So many people played Freddie's music because it was trendy at some times, then it became like a classic, and people played it as a classic.
Yeah.
But Freddie today still collects his rights
Of course,
from the music he produces.
it is his music, it is his art.
But
so-
it's just a very obvious example of why you should be you should be part of a collecting society. Obviously, I'm not going to say in Malta it has to be it's PRS,
Yes.
and I've worked with Steve for so long that he's so helpful, and also artists who are watching this know how Steve gives his life to this. And if you need any questions or need any questions to be answered, please, I think you should give your contact, Steve, and they should contact PRS for more information. Maybe
Exactly.
if you don't have enough information about it, ask them, because it's very important to collect your royalties.
Exactly.
The only asset an artist has is his music. So
Exactly.
do it.
Something I would like to add, thank you, Luke. Something that I noticed a lot, is that an artist, a creator, they focus a lot on the production of the song. They focus a lot on the music video, for example, of the song. They focus on maybe distributing the song to the radios, etc., PR. Then when it comes to registering a song, I forgot, for example.
Yes.
It happened recently, you know. There was a very talented artist, which I was watching, a new member, and I like to keep a bit of contact with a new member, so I see that they are in the right track before I leave them doing everything by themselves. And when it was time of the launch, the release date, I asked her, I said, did you register the song in our system, in our database? Oh, I forgot. How you can forget something very important? You should do this
Exactly.
priority, first thing. You know?
Exactly, but as you're saying, Steve, I think at the moment it's still not in our to-do list when it comes to creating new work. You know, it's just not there. Maybe it's not at the very on top in our
At
priority
launch,
list.
At launch of at the outset of the song, I think the plays are higher than when
Of course.
like in a year's time or in 2 years' time. So it's very important that when you master the song in a studio, as soon as the song is ready and it's on a USB stick, immediately register that song. Register that
Exactly.
song, because that is your property.
Exactly. We also spoke to Borka Usgan, who represents JESAC, and he sent us his perspective about safeguarding artists' interests across border, as well as the potential of generating revenue streams from copyright. This is what he had to say.
Hello, my name is Borka Usgan, and I'm working as General Counsel at JESAC. JESAC is the European grouping of societies of authors and composers. We are based in Brussels and working mainly on lobbying issues for the author societies that represents authors and composers across Europe. So JESAC has its members across the European Union in the member states and EEA countries, the European Economic Area, where actually are members that are called author societies or collective management organizations, for instance, like PRS that operates also in Malta, are the organizations that represent authors and composers for their collection, distribution, and management of royalties accrued on the usage of their works. So copyright is also called as author's right in the continental European countries, is a model, is a legal regime, is a legal framework that provides mainly economic rights, but in most of the member states also some moral rights to the author of the work. So this author's right regime creates a link between the author and his or her works, and then protects the author for the usage of his or her works that she created. So author's right is a right, and a remuneration is due when the protected works of the author are used by the people. So this does not need to be necessarily a monetization scheme or a commercial usage. For instance, a cultural event, non-for-profit, might also need to pay royalties for the use of the work, or the music that you might hear in a school classroom or in a train or the bus might also accrue remuneration royalties for the authors and composers. So authors and composers, the people who create the work, are not always the people also who go to stage and perform them. So therefore they are sometimes actually in many cases not known to the public. Their works are used by the famous performers or as a jingle to a commercial on the TV, or as a soundtrack to a movie, or the background music of a TV program, or to a documentary, or sometimes they are singer-songwriters and then they sing their own songs. So therefore, for the authors and composers, the collective management of rights, the role of author societies, the organization that JESAC represents, is very, very, very important. Every time a work, a creation, a composition or lyrics that are performed on radio, on television, on a music streaming service, in a festival, in a concert, in a bar, restaurant, wherever it is, a remuneration, royalties are due for the authors and composers. So since there are hundreds and thousands of usages like this, even millions of usages like this every day, and as there are also hundreds and thousands and even millions of authors around the world, this cannot be managed and exercised in an individual basis. So therefore, author societies, collective management organizations are formed by the authors themselves, and then they are managed by the authors themselves. So it's an important institution. So as there are this type of organization in every single country, they allow, whenever a song is used in any country, the collection of royalties by the author society, by the collective management organization in that country, and then this money can be sent to wherever the author is. So for instance, when a work of a Maltese author composer is played in a bar or in a television in Belgium, the Belgian Collective Management Society will send it to PRS, who will then actually pass this royalties accrued on the author in Malta. So this is a kind of this reciprocal network between the all author societies across the world, actually, all around the world. So they are able to get remunerated from the use of their works wherever they are. This allows the cross-border distribution. This allows the remuneration of the creators wherever they are, whenever their works are used. But it is also to be mentioned that collective management organizations are collective organizations for the authors and by the authors, and they are not commercial entities themselves. They are non-for-profit. They collect them, they negotiate the rates with the users, they collect those monies, and then they pay all this money to the rightful owners, to the authors, after just having the administration fee. So they cannot actually really exploit the work or can be involved in a commercial activity. So for the authors who would like to build their professional career, are usually advised also to work sometimes with a publisher, for instance, who might help the author to have its works more known across the borders, or to promote the works in other places in the world. Or they might choose to have self-management tools online. They might work with managers, they might work with the record labels for recording the music. So there are other people in the industry that are involved more with the business side, but collective management organizations are the guarantee for the authors all the time, whatever their contracts with their record labels or with their publishing companies, they are always due to get a remuneration from the use of their works. And the recently adopted copyright directive ensures this as well. It creates several new provisions that strengthens authors' right and strengthens collective management. First of all, it allows authors now to get properly remunerated from the use of their works on the online content sharing service providers like the services YouTube or Facebook, who have so far been the main source of the usage of the creative works, have not been paying to creators properly, if at all actually. So now they will have to do that. And then for this also collective management is one of the best solutions for the authors to get remunerated from all those usages. And another provision of the directive is the Article 18, which also protects the creators, which says that all creators should be remunerated for all usages of their works. So this can allow them, this could allow them to have a better protection against coercion or the pressure in the contracts with the industry players. So, as I said, Article 17 against the big media, big internet platforms like YouTube and Facebook protects the creators, and other articles like 18 ensures a remuneration scheme. There are other schemes that are providing new remunerations for the authors and use of the collective management system, but I'm not going to go into detail of that in this limited time. I would like to thank you for giving me the chance to address the audience of the Maltese Arts Council, and I'm very honored to be invited and to address you. I wish I could be with you today, but that was not possible, unfortunately. And for any questions that you might have, I'll be happy to answer them through email. Thank you very much.
So thank you, Borka Usgan, for that, those insights about copyright and particularly about cross-border collaboration and protection of rights. So I would now like to introduce our last guest today, Maria Gallia from Arts ID. Maria represents the visual art sector, and we'd like, although we have very, very limited time, so we don't have the much time to go into the detail of each and every art form, but we thought it could be very interesting to also see what visual artists and how visual artists are coping and are covering their rights. So Maria, welcome to this discussion. How aware do you think that the visual artists are of their rights and of how they can protect their rights? And what are the challenges which you face, and what can be done in order to address this further?
Thank you, Elaine. Thank you for inviting me. I mean, today, visual arts, like any other means, has taken its form online, both through social media, both through online portfolios, and that makes it more accessible. It can be in a good way and a bad way. I think visual arts is the one of the most forms which can be, let's say, used for other purposes and copies. Simple screenshots can be taken and repurposed. So that can be dangerous. Registering copyright of the work is a prevention, right? And gives artists like a more solid proof in a scenario where they have to encounter someone else reproducing or using their work for other purposes. Also, as you already mentioned, I think artists are usually more preoccupied about the process and the result. Taking an inventory, for example, of their work, where it is being sold, where it is being exhibited, collecting the provenance of that work, copywriting, that is all very important when it comes to different scenarios, both from a legal perspective. If they had to encounter, I'm not a lawyer, but if they ever had to be in a scenario where their work is being used for something else, all that evidence can be very, very helpful. However, even from a professional scenario in terms of selling their work, it is very important even for the clients and even from a gallery perspective that they are documenting their process and documenting their works and obviously, each work has its own certificate of authenticity, but having that copyright, it adds more certainty to the person who is also investing in that artist. I think one of the most important things which I usually go over with artists are agreements. Agreements whereby even a commission or representation abroad, they need to be very, very specific in the intellectual property of their work, even for public commission and the reproduction of that work. For example, sometimes an artist creates a public commission or a piece of work which had a lot of exposure, and then they recreate prints out of that work. Having the right to do that is very, very important, and I keep on stressing on this a lot. I think something which we haven't mentioned or mentioned in another way are the resale rights of the work. Abroad, even in Malta, I don't know, but music and composers and songwriters, this is more something which is happening more than the visual arts scene. I believe in 2001, there was a new law in Europe which underlined the resale of artworks, and 4% of that resale value should go to the creator. For works of 1,500 and more. I think this whole process has not been underlined enough in the art market, both from auctions, art dealers and galleries. I think it should be more, people should be more aware about this, and it can also be another added income for artists, for people who and dealers and other institutions who are buying their work and reselling it. Just one last thing, another important thing for artists, both having a copyright or signing a copyright license agreement, are the royalties that can be generated from this abroad. And I've also had some experiences where artists, their work was used on, for example, fashion brands, and that actually generated a very good revenue in terms of the royalty on the sale of each product. So that is something which artists should take into consideration of their works. Just one last thing, there is in the contemporary art market, there is obviously the visual art product, and then there's the concept. As Dr. Luke Daly said, the idea is not protected. So I think in that sphere, the conceptual artist is a bit more exposed and unprotected. Yes, that is. I think I've outlined everything.
Thank you very much, Maria, for those comments. Don't know if you can maybe.
Kicked off by saying, I am not a lawyer, no. But she has outlined perfectly the visual arts world in relation to intellectual property. You have seen now, it's not just me, a lawyer, coming from the theoretical part, but also in practice. Maria has given you perfect tips in relation to this subject. So to have a good inventory, to know where your art pieces are being put up, viewed, resold, the rights that are attached to such a resale. There is legislation, there are laws that protect that. And as Maria perfectly said, any relationship you have with a third party, with someone else who will be using or selling or reselling, whatever, your artwork needs to be regulated. She mentioned agreements, and I completely agree with her. Agreements regulate your art form, be it music, be it visual arts, be it any art form. It's regulated with a written contract or agreement. So please do not do anything, do not pass on the most precious possessions you have, that is whatever comes out of your hands, your eyes. For example, photographers, their intellectual property is the way they see the world from their camera. You know,
exactly.
it needs to be regulated, it needs to be protected, but at the end of the day, lay it down, write it down. A contract, an agreement, it doesn't need to be complicated, doesn't need to be super bombastic, very legal, but at least you have something that regulates that relationship.
Exactly. There are so many other things which I wanted to discuss. I mean, we didn't really have the time to go into the streaming rights, for example, and what happened at the beginning of the pandemic. I think it's important, but it's now time for us to conclude the session. Steve, I don't know if you have maybe your
maybe
final remarks.
Yes, maybe to conclude, I think what came out from this discussion, and I highlight, is awareness. How much important for a creator, the awareness. So if you are a creator, you don't know anything, the legal aspect, about royalties, about trademarks, ask. There's no harm in asking.
There are professionals.
Exactly.
And
you can
refer to
contact a society like PRS. We give free consultation, not only to our members, but also to music users that they would like to use music in their business. You can find also help from a solicitor, like Luke explained very well. Arts Council Malta as well. I'm sure that if you contact also the Maltese departments here in Malta, they can guide you, they can lead you where one needs to go to answer these questions, because these are very, very, very difficult questions as well.
Very pertinent.
Exactly. So yes, I think something that I highlight very important from today is the awareness of what is your right, okay, and also the music user, what is yours and what is others' right.
Dr. Dalli, your final concluding remarks?
The sustainability of any art form is based on what the artists know and apply to their art. If you do not know, ask. If you haven't understood, read. But please, being an artist is a talent. But being aware of the rights attached to that talent need studying, need asking. No one knows everything. Myself, I like every day I read an article and say, listen, I didn't know this. So ask. The Arts Council, PRS, your lawyers, solicitors, whoever. Get information, because at the end of the day, information today, at this day and age, is power.
Thank you very much. So I would like to thank Arts Council Malta for hosting this ACM Hangout, a very interesting ACM Hangout, I must add. Thank you to our guests for being with us today and for contributing to this conversation. Feel free to leave us a message on the Arts Council Malta Facebook page if you have any comments or any questions, or if you would like to discuss further. See you next month for another ACM Hangout session. Take care.